When we talk about phantom damages, we're talking about sort of a number of related things that the plaintiffs' bar typically engages in to create fictitious evidence of damages to boost the kinds of awards that juries will hand out. Just to take one example, I mean, most people are familiar when they go to the doctor or go to the hospital, the kind of raw billing rate that might be lurking behind the scenes is a lot higher than what the patient actually ends up paying after you take into account the discounts that the providers have negotiated with insurance companies or with Medicare or Medicaid or what have you. So there's a sort of rack rate that nobody basically ever pays. So if you have a medical bill that's higher than it should have been or higher than the plaintiff is going to pay, then that's the difference between those two is a windfall for the plaintiff and their lawyers, who of course are getting a percentage cut of any award.
Always, the bigger the damages, the bigger the reward, the bigger their fee's going to be. This is something that their business practice is modeled on. Getting those damages as high as they possibly can, the sticker price of what a hospital charges, not actually what is recovered during the process.
It kind of sets a higher baseline for other awards of damages that juries typically hand out, less objective kinds of damages like pain and suffering damages, for example. If you start with an inflated medical damages number, you're potentially prompting the jury to also award an inflated non-economic damages number. So it is one of many techniques that the plaintiffs' bar uses to generate these windfalls, to turn the civil justice system from a system for making people whole to producing windfalls, producing jackpots. What several states have been doing in recent years is curbing the ability of plaintiffs to play these games and insist that the jury should hear about what the real situation is and what these procedures should have cost or really did in fact cost, as opposed to essentially a fictitious number that the plaintiffs are creating.
Jurors want to do the right thing. I've been in several trials, and I've talked to jurors after deliberations, and they wanted to do the right thing. They wanted to be fair, and they wanted to bring closure to a situation that is tough for everybody that's involved in the lawsuit. The problem is they don't know what they don't know, and when they're getting incomplete information, example going back to the medical bills, when they're being told that medical bills are $500,000 and not the actual paid amount of $200,000, they're being given inaccurate information. They're not getting the whole picture. Transparency is important. So what is the harm in telling jurors, well, this is the amount that somebody actually paid, and giving them all the information that they need to truly go back and deliberate and make a fair and just decision?
Everything in the lawsuit abuse crisis ultimately affects the economy, affects consumers. When trucking companies are forced to pay these unconscionable verdicts that have no real connection to the injuries at issue or the trucking company's own liability, those are costs that are ultimately going to get passed down the supply chain. They're going to affect what it costs to transport goods, and everybody in this country is very dependent on trucks to deliver the things that they need and use every day. So this is a cost on the supply chain. This is not free money, as juries often seem to treat it. It's money that is going to have to come from somewhere, and ultimately that's the American consumer.